Yeah, we'll work that out with our Good morning, everybody, and welcome to the second day of our symposium, Gideon at 50, Reassessing the Right to Counsel. I think the panel last night got us off to a great start, and I'm looking forward to the three panels today and Steve Benjamin's remarks as keeping that positive momentum going. First of all, just a few housekeeping matters before we get into the substance of today's panel. I've been asked to remind you, all the participants, that in your folders are video release forms. If you could get those signed and returned to us at some point, that would be terrific. It would be easiest, I think, for all of us if you did it while you were here, but certainly if you forget, it's not the end of the world. We'll just have you sign them and get them back to us some other time. Second of all, I'd also just like to remind all the panelists that when you're sitting and answering the questions afterwards, I think everybody projected very well when they were standing up here, but we had some issues with people hearing when the panelists were seated last night, so if everyone could just remember to try and speak up so that everyone could hear you throughout the day today. And also, was there one more thing you wanted me to? Oh, right. And the other thing is our student body is very busy, and they have a lot of class during the day, but they are very excited about the symposium and will be passing in and out throughout the day. So hopefully when panels are in session, the people at the registration desk will be reminding them to be quiet and unobtrusive as they come and go. But just be prepared for that when you're making your presentations, and we look forward to hopefully getting the biggest audience we can. So, without further ado, it's my great pleasure to introduce our dean here at W&L Law, Dean Nora Diemleitner. Dean Diemleitner graduated from Bates College. After that, she proceeded to get her JD at Yale and then earned an LLM with distinction from Georgetown. She proceeded to clerk for then Judge Samuel Alito on the Third Circuit, and since entering the academic world, has become one of the premier scholars in her area of expertise of sentencing law and collateral consequences. So please join me in welcoming Dean Nora Diemleitner.
Well, good morning, everybody. First of all, while I appreciate Alex's kind words, I think the preeminent and premier scholars are in this room. Now, I am delighted to see all of you here this morning, and I was really energized yesterday by the exciting and truly stimulating conversation about Gideon, the challenges with which it has left us, and the question really of where to go from here. And I'm entirely confident that today's panels will be even more exciting and more thought-provoking than even yesterday's, especially as we're continuing a conversation throughout the day. Now, as Alex mentioned, I feel that this conference is a little bit of a windfall for me, because I didn't have anything to do with its planning. It was decided on long before I decided to come here. But collateral consequences and sentencing have been near and dear to my heart for a long time. And so I was thrilled to see that many of the questions about representation at trial or during plea bargaining ultimately deal with the end game. The question of what will the sanction be that's being imposed, and equally importantly, what are the collateral sanctions that are flowing from any type of conviction. Now, as I was thinking about that, it occurred to me that Gideon was really decided at a very different time. Collateral sanctions were declining at that point. Really, even mandatory sentencing seemed to be kind of vanishing. A time we have trouble, I think, imagining at this point, where we're facing harsher sentencing and what seems to be an ever-overflowing panoply of new collateral sanctions, however we call them, and they seem to be imposed on an ever-larger group of people. Now, what struck me as encouraging in the last few years is that with the state budget crunch, I think some states have become really innovative in terms of thinking about non-prison sanctions, in thinking about new ways of dealing with criminal offenders. Now, this symposium, of course, sees the flip side of that, namely the cut in funding, increasingly so and over time, of the right to counsel and defense. Now, what that will mean, of course, we'll see in much more detail today, how Gideon has morphed in practice and how we're going forward to guarantee the protection of rights and perhaps even fairness in trial and plea bargaining. Now, I think it's really not just a credit to W&L to host this conference, but it's so indicative of what W&L is all about. This conference brings together top-notch practitioners and legal academics to discuss these issues. Obviously, I'm particularly grateful to the Francis Lewis Law Center, which is our support for academic thinking and scholarship, and NACTO, not just for their financial support, but also for their intellectual support of this conference. At W&L, we're particularly proud of student governance, and I think this is a great example of it. The Law Review is doing a marvelous job with Carney Simpson and Alex Shurgster of executing this symposium, of course always with some sage advice and a guiding hand by Professor J.D. King. So I credit them for bringing together an unbelievable array of people and ultimately for putting out an impressive symposium issue with the papers that all the panelists will present today. Now, I have to admit, while I love thinking about sentencing and collateral sanctions, I couldn't help in some of the papers thinking that they have a lot to do with the life of a dean. Holistic decision-making that you heard about yesterday, or advice-giving, clearly something that I think deans should at least be thinking about all the time. I was teasing Ron Wright and Ralph yesterday about the fact that their North Carolina database sounds a lot like performance reviews, which deans have to do regularly. And then, of course, the question of when and who to fund, what kind of public defense service to fund, may sound like need or merit-based scholarships. And I know none of you thought I could connect the life of a dean with these papers. Now, I do want to leave you, though, with one challenging thought, which doesn't go to your life as a legal scholar or even, to some extent, as a legal practitioner. But I think it goes to your life as law school teachers and legal professionals. Some of the proposals you're making have great consequences, not necessarily for curricular development, but for the future of all law school graduates in the sense of what job opportunities will be available to them. If you're constricting the right to counsel, there clearly will be perhaps less need for young lawyers in the market. If we were truly expanding it, we would have to fund it in light of the tuition levels of today's law schools. So it seemed to me that your papers have a second component to that, which is the question of what will the legal, the group of legal defense lawyers look like in the years to come. So I'm truly excited about today's panels, and I will turn the microphone over to the first moderator of this morning, Norman Reimer from NACTO.
Thank you very much, Dean, and thank you to Professor King and the Law Review and everybody for the fantastic job they did. I'm tremendously honored for NACDL to be a participant in this very, very important conversation. We believe that Gideon was rightly decided. We do not lament Gideon. We celebrate it. In fact, we don't lament any of the cases that have flowed from it. Archer Singer, Shelton, Padilla, Lafler, and Fry, and all the rest of them. NACDL does not believe that the systemic shortcomings should cause any retreat whatsoever in the expansion of the access of the right to counsel for the poor accused. The problem is not the right to counsel, and it most certainly is not the Supreme Court decisions that right should be accessible for the poor. Unless we want to completely and totally fracture our society, any suggestion that the right to counsel, the right to appointed counsel, should be limited in any class of criminal cases should be accompanied by a call to prohibit counsel in similar classes of cases for those who can afford counsel. Otherwise, all you're doing is simply saying that it's a right but it's only a right that's available to those who can afford to purchase it. And that's wrong. It's wrong for justice. It's wrong for everything that this country should stand for. The problem we face simply is not the right to counsel. It's an abuse and a misuse of the criminal justice system. It's over-criminalization and over-prosecution. You all know the stats very well. You heard some of them mentioned again yesterday. 2.3 million people in prison. There are varying estimates, but I've heard estimates of somewhere between 60 and 70 million people who have criminal convictions in this country. It raises this fundamental question. Are we a nation of criminals? Are we a nation of bad people? I don't think so. We are a nation who has made some bad choices. We are a nation whose political leaders from both parties, all political ideologies, have cynically used the criminal law as a tool for social and regulatory control and, frankly, for demagoguery. And so we have gotten ourselves into a mess where we are using the criminal law for all kinds of things which are detached from its fundamental purpose. We need to diminish the system and not diminish the right to counsel. In a moment, with a truly, truly outstanding panel, which I am so honored to be even associated with, we're going to focus on an area where the need is probably the greatest, where the abuse and overuse of the criminal justice system is so clear and so tragic, with such horrible consequences for our citizens and the people who live in this country. And that is the area of misdemeanors. My organization was a pioneer in highlighting this problem several years ago with our report on misdemeanor courts, minor crime, massive waste. We've done a follow-up report called 3-Minute Justice, which looked very closely at a number of counties in Florida. And in a few moments, we're going to have a terrific conversation with these phenomenal panelists. I want to start with just a brief personal introduction and a brief discussion of what my organization is doing to celebrate Gideon. Just for those who don't already know me, I spent my entire career as a criminal defense lawyer. I consider myself a criminal defense lawyer. I always will until the day I die. That's what I am. That's what I always will be. I was drawn to this at a very young age. I was fortunate to get into a school where there was a clinic. That's why I sought out the opportunity to go to that school. And since my third year in law school, and for the next 28 years following that, until I came to NACDL, I spent every day of my working life representing people in every kind of case you can imagine. And I spent a lot of my time working on indigent defense issues. I never was an indigent defense provider in the sense of working for an organization. I never worked for any organization. As a result of my clinical experience, I went directly into private practice. I was fortunate enough to have a case while in the clinic where the co-defendant was represented by a prominent private attorney who invited me to come to work with him. And the rest, that's been my entire career until I came to NACDL, was at a small firm where we did a considerable amount of assigned work. But I also had an opportunity to be present at one of the most historic eras in the history of indigent defense, when the Legal Aid Society in New York was striking, not for personal benefits, but for the right to be able to represent a client vertically from start to finish. I worked alongside some of the most committed and dedicated public defenders. Back in those days, there was no such thing as a criminal defense lawyer who didn't do some work for the poor. That just didn't happen. And over a course of a number of years, I became involved in reform of the system through task forces on indigent defense, through the chairmanship of the committee that oversaw 1,200 private lawyers who took assigned cases and did the first recertification in a generation. And that was painful, to impose standards and do a meticulous review and end up eliminating basically 200 people from that panel and perhaps ending their livelihood, but because it was necessary in order to ensure quality. So I have had a keen interest in this subject throughout my career. As far as NACDL goes, we decided that, Gideon is who we are as people. It's what we are about. It's what we as defense lawyers exist for, to be able to stand beside the accused, to have the privilege of representing somebody who is at perhaps the lowest moment of their life and in the greatest need of some assistance. So we decided that we wouldn't just do a particular celebration next March when the actual 50th anniversary rolled around. We decided that we would celebrate it for 15 months. Now, how did we arrive at 15 months? We decided that we would celebrate it from the moment in January of 2012, which is 50 years from the filing of the pro se petition, the handwritten pro se petition that Clarence Earl Gideon wrote, right through the decision. And we decided we would do it in a number of ways, some of them just sort of symbolic and some of them much more substantive. We put out our calendar for the year, 15-month calendar, which celebrated Gideon. A reminder for all of our lawyers and all of those who subscribe to our magazine of the importance of this event. But we decided to take on some really substantive issues as well. And we created a task force on pretrial justice. And that task force has taken a look at some of the core issues that our bar association, the organized criminal defense bar, really hadn't focused on for quite a while. And we adopted a number of policies. Not chronologically, but the two that we adopted were a position on pretrial release. We have now formally stated that we oppose the use of bail bonds. We believe that money bonds should be used only in the rarest of circumstances, that there should be a presumption of release, and that release decisions should be based on evidence-based practices. Essentially, what we're trying to do is, at least from the standpoint of the organized criminal defense bar, go on record as being opposed once and for all to the use of bail as ransom, and get that horrible, horrible tool out of the hands of the criminal justice system. The other issue that we took on was the right, when should the right to counsel exist? And in contrast to some of what you will hear at this conference, we have taken the position that the right to counsel should be present at any time when liberty is being determined by the court, and at any time where a conviction may be entered. We do not think that jail should be the determinant factor, not in this era of collateral consequences, which are really not collateral, as I will mention in a second. In addition to that, we've recently launched something called the Restoration of Rights Project, which is a publicly available tool for those who want to find out what mechanisms exist in each of the 50 states in order to get rights back after a person has been convicted. And we have a task force on the restoration of rights and status after conviction, which is in the process of conducting 2 years of hearings in a number of cities around the country, and will eventually, hopefully, come out with a series of very specific recommendations as to what needs to be done to eliminate the legal barriers that people who are convicted face. Another thing that we've done is proudly support this symposium. We also, our Indigent Defense Counsel, who you will hear from later, John Gross, is working with some wonderfully talented students on the preparation of a report on indigent defense, which will look at appointment mechanisms, determinations of indigency, and compensation, and that will be ready next year. Another thing that we've done, which I want to bring to your attention, which may at some point be useful in the discussion about how ethics can play a role in all of this, is our Bar Association recently adopted an ethics opinion that concludes that 2255 waivers that require the waiver of any prospective claim of ineffective assistance of counsel are unethical. We were asked to render this opinion by 2 districts. We think there are 13 federal districts. And of course, although the opinion specifically was asked to consider the 2255 waiver provision in that context, this applies equally to a lawyer in the state who's being asked, in a state proceeding, who's being asked to counsel the client to waive a future prospective claim of ineffective assistance of counsel. We also continue to support reform in a number of specific states, New York, Michigan, Maryland, Colorado. I'm probably leaving a couple out, but we're also very pleased to have provided direct support to the effort in New Mexico, which was successful this past Tuesday. There, a ballot initiative that establishes the independence of the Indigent Defense Commission passed. so that now they'll move on to the implementation. But this now takes the sole control out of the hands of the governor and establishes some independence. The last but not least, one of the things that we did this year was we published this special edition of The Champion, which is available out there. The Champion magazine is one of NACDL's flagship member benefits, but I am so proud of this issue. It's meant to be informative, provocative, entertaining. It's really a tour de force of the 50 years of Gideon, and I want to share something with you which just absolutely thrills me. We have a magnificent art department, and we've won some design awards. But this particular issue of The Champion has been nominated by an industry group in the media industry for an award for its content. And what excites me about that, of course, is not just that people thought that it was well written and well articulated, but people had an interest in the subject matter. And to give you some context, some of the other nominees in this category are Entertainment Weekly, Time Magazine for its parenting edition, and my favorite, Food and Wine's Super Chef's Recipes. So right up there is The Champion, Gideon at 50. So you should all be, in a way, you should all be proud about that. I also want to mention one other thing, which is that it's, for me to be in the presence of so many scholars and academics and thinkers is obviously a great privilege. I do not put myself anywhere in that category. I'm a practitioner, and now I'm a bar executive. But the fact of the matter is that what you do is so terribly important. And what we're doing within the next few weeks, we will be launching a new feature in The Champion, as we are going to be highlighting. We've got a team of wonderful faculty people who are participating in this project to identify articles that we think will be useful to practitioners. And we'll be asking the authors of those mostly law review articles to condense them and provide a handy condensed version so that practitioners will be aware of these things. Good practitioners will find the scholarship when they have to write a brief, when their issue is presented for them. But wouldn't it be great if we could be alerted to some of these things so that we can start thinking proactively about how to use what you're thinking about and what you're writing about? So that's what the object is. The topic of this particular panel, Gideon and Misdemeanors, Unanticipated Consequences and Enmeshed Penalties. And I'm so grateful to Robin for using the term enmeshed yesterday. The term enmeshed is really what it is. And this is the thing that we can't lose sight of. It is critical to this discussion. These consequences that we're talking about are not collateral. They are direct. They are palpable. And they are life-altering. And that's why we've taken the position we've taken about the right to counsel being necessary whenever a conviction is at risk. So I'm eager to get into this discussion. And I want to just very briefly introduce the three panelists. All three of them, they share a number of things in common, some of which are obvious, and some of which may not be so obvious. They are all former frontline defenders, which to me warms my heart and means that whatever you're writing and thinking about is informed by the experience that you've had in or continue to have in representing clients on the front lines. So Erica Hashimoto from the University of Georgia, formerly a federal defender. She has written on the problem with misdemeanor representation, in which she will talk about noncompliance with the right to counsel, the need for data, and possible solutions. And then Alexandra Sasha Natapoff, professor at Loyola Law School in Los Angeles. She's written on Gideon skepticism, where she talks about the hydraulic pressures that have turned misdemeanors into engines of injustice. And she talks about the limits of what counsel can do in the face of overcriminalization and mass processing. And Jenny Roberts from American University, where she heads up the criminal justice clinic there. She's previously written an article called Why Misdemeanors Matter, and today the paper that she's got the draft circulated and thinking about is Crashing the Misdemeanor System. Jenny suggests that we fight the problem by deploying greater resources and even more zealous advocacy misdemeanor representation. I also want to mention, as a matter of personal pride and privilege, that Jenny is also playing two very key roles for NACDL right now. She is one of 3 co-authors of a book on collateral consequences that will come out next year under what we call NACDL Press. We are now in a joint publishing arrangement with Thomson Reuters. Those of you who like to write, please see me if you'd like to have your book published and marketed directly to 40,000 criminal defense lawyers. We're very excited about this treatise. I believe it's going to be an indispensable tool for lawyers wherever they are, whatever they're doing, whatever their practice milieu. And the other thing that Jenny is doing for us is she's serving as the reporter for the Task Force on the Restoration of Rights and Status After Conviction. And she's going to play a pivotal role in helping this magnificent task force pull together these recommendations and what will probably be a transcript of probably close to 5,000 pages by the time we finish the hearing. So she's got her work cut out for her. So with that, I want to turn this over to Erica.
Thank you all for pulling this all together, and thank you in particular for paying some attention to misdemeanors. So there has been a lot written about Gideon by academics over the past 50 years, and interestingly, the bulk of the criminal justice system and the role of counsel in that bulk of the criminal justice system has been largely ignored for most of that period. And I'm obviously talking about all the misdemeanor defendants and what we do about them. I think all of us sitting at this table would agree that the misdemeanor system is in total crisis. It is a mess. And that is so for a lot of reasons. It is where overcriminalization has played out the most. As Robin talked about last night, there are all sorts of penalties associated with conviction in misdemeanor court that have huge ramifications for people who are convicted. And the question is, what do lawyers, what can lawyers, and what should lawyers be doing about it? The real difficulty, as I see it, is that to the extent that counsel are being appointed, in many jurisdictions, they do not have the resources to do very much at all. And I recognize and applaud what the fantastic offices across the country are doing. My experience, so I'm in Georgia, and Georgia has really been struggling to put together an indigent defense system and has made great strides towards that. But I'm sending my students out to be public defenders in the state of Georgia, and they call me all the way through, and they say, I can't do this because I've got 500 cases. I can't do anything with any one of them. Is there anything we can do to get help? And so that kind of is my starting point for talking about misdemeanor representation. I am a data person. I know it sounds stupid, and a lot of people are not data people, and they think, why do you care about data? The reason I care about data is because I think there is a very strong narrative in there. And one of my real concerns about misdemeanor defendants is you do not have Clarence Earl Gideon and Clarence Earl Gideon's story, right, in the misdemeanor context. We don't know what's happening in the misdemeanor context. We don't have any data on how many people are actually being represented. The NACDL has done 2 fantastic reports that Norman mentioned that document the extent to which people are or are not being represented in misdemeanor cases. There are really, really blatant violations of Argersinger, of Alabama versus Shelton, going on in states, and you've got the state saying, we don't really care. I think that's really problematic for a lot of reasons, but we're not just talking about the council don't have enough time, or they don't have enough resources, or they're not meeting the Strickland standard. Instead, we're talking about people who have a right to counsel who are not being appointed counsel. And there are, from what we can tell, a lot of people in that situation. What we don't know is how many, what percentage of misdemeanor defendants that is, and whether the extent to which anybody who is in particularly the Alabama versus Shelton sentenced to, not to an incarceration sentence, but to probation or suspended sentence enforceable through incarceration, we have no idea how many of those folks are not being represented. I set forth in my paper the kind of sources of data that I've looked at, and none of them tell a good story particularly. So, you've got the Argersinger defendants who are interviewed in local jails. The Bureau of Justice Statistics has some information from them. There is a survey that they do of defendants who are being incarcerated in local jails. These folks clearly had a right to counsel under Argersinger, and 30% of them say they were not represented. And so, this is kind of the clearest class of people, of misdemeanor defendants who have a right to counsel. Now, it is a very small sample. There's all kinds of caveats to the data. But for that class, to have that level of non-representation contrasted with the felony side, where we are at about 98.5% to 99% represented. The people who are not represented, at least in urban areas, are affirmatively choosing to not be represented by counsel. And it appears that the waivers are at least relatively knowing and voluntary. On the misdemeanor side, you've got these much, much, much higher numbers of people who are, or percentages of people who are clearly entitled to the constitutional right to counsel who are not being represented. So that brings you to, what do you do about it? And that's where I think I really struggle, because I understand Norman's point that all defendants should be represented. And I totally understand that argument. I guess what I would say is that I think we need to make sure that those who currently have a constitutional right to counsel are actually receiving that right before I'm going to worry about the folks who don't have a constitutional right at this point. And so part of my real struggle is we are doing such an awful job, even presenting a warm, live body with a heartbeat to people who have a constitutional right to counsel. We haven't even gotten to that point yet with people who the Supreme Court has said have a constitutional right to counsel. And so I really, for my purposes, want to focus on that group that already has a constitutional right to counsel and are being denied that. And trying to figure out what to do about that is really difficult. And I think all of us on this panel are struggling with that, and how do we either reduce the number of misdemeanors and get rid of the criminal consequences altogether, or shut down the misdemeanor system, or what do you do to stop all these cases flooding through that public defenders really don't have the capacity to handle right now? So a couple of people asked me last night, all right, so what's your solution? I didn't see a solution in your paper. And that's part of my problem. I'm really struggling with that. I have taken the position before, and I am sticking with that, I think, that as long as the constitutional right to counsel is structured as it is, we need to be doing a much better job keeping data on defendants who have a constitutional right to counsel in misdemeanor cases, and then trying to hold the state's feet to the fire and try to force them to change the penalty structure if they are not going to provide counsel, because to the extent that you can give the state the option of either decriminalizing or changing the penalty structure so that there is no right to counsel, I understand why people say that these additional consequences in addition to imprisonment should be leading to a right to counsel. I guess my bottom line is that I think we need to take the baby step toward at least getting live bodies next to people who have a constitutional right to counsel before we can take the next step, which is to try to expand the right to counsel to more misdemeanor defendants. And so I'd really like to hear from people about other ideas, other things that we can do, other than, and as I've said, I'm a data person, so I really want to know who is being represented and who is not being represented. And I'm going to wrap up with this. One real benefit that would flow from guaranteeing counsel to anybody in any criminal case is it would make the data much easier to track. So part of the difficulty with misdemeanor defendants as opposed to felony defendants is we know all indigent felony defendants have a right to counsel. By contrast, indigent misdemeanor defendants only have a right to counsel if upon conviction they either get a probation sentence or an incarceration sentence, something tied to incarceration, which means that in order to know what percentage of misdemeanor defendants have a right to counsel, we have to know what sentence they got at the end, which it feels a little backwards. And so one benefit of, in addition to all of the other benefits of guaranteeing a right to counsel, is we could at least provide a much clearer picture of the extent to which the constitutional right of defendants is being violated. But in the absence of that, I do think we need to be creating a more compelling picture of what is going on in the misdemeanor system where, as I say, we're not even providing live bodies to the people who have a right to counsel. So I look forward to hearing people's thoughts and questions, and with that, I'll turn it over to Sasha.
Good morning, everyone. I want to thank JD and the Law Review for having me here today. What a fantastic symposium. I was struck by how much convergence there was in the papers in folks thinking about new ways to conceptualize the role of counsel in the kind of criminal justice system we have. I think this is really valuable, a really valuable endeavor. I was also struck by something, Norman, that you said, that for so many defense counsel, Gideon is who we are, right? That in many ways part of the role of defense counsel is to understand our role as the guarantors of fairness for defendants and the criminal system. And it reminded me of a couple of friends of mine from the Federal Public Defender's Office in Baltimore where I used to work. They're lifelong defenders, sort of 10, 20 years in the office respectively. Their third child, middle name, Gideon, right? So this is how people think. Right? And I think it's true. And I think that we have to recognize that it's not enough. And that in many ways to understand the role of counsel, we have to understand the nature of the criminal system that we have. And the capacities of counsel to ensure fairness really depend on the way we structure our criminal justice system. And that's why misdemeanors are so interesting, because as Erica pointed out, they just push the boundaries of so many traditional notions of adversariality and other sort of due process norms that we think characterize the criminal system, but that we see very clearly in the misdemeanor process that they really don't. So this paper is an effort to think about the limits of lawyering, right? The limits to the capacity of a defense adversary to ensure not only fairness for an individual defendant, but fairness in the system more generally. And to look at the way that we have conferred the burden and responsibility of ensuring fairness on the institution of defense counsel through sort of the spirit and the mechanism of Gideon, and to think about the limits to that model. So one of the problems is that we have no idea what a criminal justice system with fully functioning defense counsel looks like, right? I think, Stephanos, you make the point in your paper, we probably never will. And so we don't have the ability to actually look at a system and say, here's the limits, here are the inherent limits to the role of counsel, because we don't have a system in which counsel is sufficiently funded or resourced so that it can actually play the role that Gideon might have theoretically envisioned for it. So instead we have to imagine, and so in some ways this paper is an effort to imagine what lawyers couldn't do even if they had enough time and resources to do it. So that raises a couple of questions, one that I address in the paper, or try to address in the paper, and one that I punt on. One is to think about what is it that lawyers are good at, right? What are the mechanisms by which we think that defense counsel can and should and are able to enforce fairness norms in cases and throughout the system? And then, of course, that also raises the question of what do we mean by fair, right? What are the ultimate values and norms that we think that defense counsel should be enforcing? And I punt on that one in the sense that I just sort of posit there's a whole range of ways of understanding fairness. I don't have a theory of fairness in this paper. Instead, I'm more interested in the question of whatever we think the criminal system is supposed to do or how individual cases are supposed to work, to what extent can lawyers do that, right? To what extent can lawyers fulfill that function, and to what extent can't they? So on this question of what lawyers are really well designed to do, what role defense counsel is well designed to effectuate, one way of looking at that is to ask, what does the Supreme Court think that defense counsel are good at doing? And then to notice that in many ways the Supreme Court, through its various doctrines, not only of Gideon but ineffective assistance of counsel, have in many ways substituted the question of effective counsel for other notions of fairness. So in large part we don't ask directly, was a defendant's plea voluntary, knowing, and intelligent? We ask, did they have competent counsel when they made that plea? And that is going to be enough of an answer for us. In many ways, we use the metric of ineffective assistance of counsel to ask whether the results of a trial or a proceeding are fair. We're constantly looking to counsel rather than underlying issues of voluntariness or fairness or accuracy. And so the right to counsel has assumed this validating role in a way that I think we should rightly have skepticism about. It may not be enough to have competent counsel to ensure that a plea is voluntary or that a plea bargain is proportional or fair. We may have to look beyond the role of counsel in the way that the Supreme Court has gotten into the habit of doing. There's also a deeper skepticism about the role of counsel that a number of scholars have identified over the years to understand that because of certain features of the way we structure our criminal system, sometimes there's not that much for defense lawyers to do. Right? So the famous arenas are the federal sentencing guidelines, in which a number of people have pointed out that the role that because of the way the sentencing guidelines are structured and the way they confer authority on prosecutors and limit the adversarial role, there's often a very constrained role for defense counsel. Similarly, with mandatory minimum sentences, there's a constraining effect on the ability of defense counsel to act in a meaningfully adversarial way. In a similar vein, although I think in a less direct way, the new focus on accuracy, which I think of as a child of the innocence movement in many ways, the idea that the primary metric for fairness of the criminal system is the accuracy of outcomes, in many ways operates to cabin the role of defense counsel. It used to be that we thought we got accuracy by having a robust adversarial process, and the defense counsel and the government would fight it out. And now, the innocence movement, of course, Brandon is a great contributor in this regard, has persuasively demonstrated that we need to look earlier in the process, even before the adversarial process starts. We need to put pressure on police to engage in more accurate investigative processes. We need to be more careful about forensics. We need to record interrogations and lineups and the use of informants. But this is clearly all necessary and true. But I just want to point out that in many ways, it's moving away from the model in which defense counsel's job is to ensure accuracy. And there's a spirit in that movement towards accuracy, which in many ways, and I think we need to be careful about this, suggests that if we had really great investigative processes, we might not need defense counsel so much, that in a way the adversarial work would have already been done through the reliability of forensics. And so I see that, also that trend away, sort of a light skepticism, if you will, about the role of counsel in that regard. So in some ways, I chart out this idea of Gideon skepticism in part in order to locate misdemeanors within this world. I think that, as Erica described and as the work of many people in this room has made clear, misdemeanors belong firmly on the list of places in the criminal system where we need to be very skeptical about the ability of defense counsel to guarantee the kind of fairness that we think that the system should reflect. And in part, this is about the famous, infamous underfunding and overburdening of defense counsel themselves, that we have constrained actual lawyers, actual public defenders' offices from their ability to do the job that we have conferred on them. But because the misdemeanor system is so large and proceeds in such a non-adversarial way, in which police and prosecutorial decision-making really can overdetermine the outcome before anybody gets to court, that feature of the misdemeanor process, I think, is just as powerful in reducing the possibilities for adversariality and for the role of the individual defense lawyer. And even for good defense counsel, right, it's very hard to make that system adversarial. I think of this as Josh's great point that he made in an earlier piece, that even for an innocent defendant, right, a rational, innocent defendant might well choose to plead guilty in order to go home, in order to get out of the misdemeanor process, which is another way of saying there isn't really that much for his or her lawyer to do. So in that way, we have marginalized the adversarial process and therefore defense counsel in a system that makes it rational for people to plead out and not engage those processes at all. So what would it take? If Gideon isn't enough, even if fully funded Gideon weren't enough, where else should we look for systemic guarantees of fairness and accuracy, in addition to the kinds of proposals that Erica and Jenny are proposing? Even if we had the best lawyers staffing the misdemeanor process, for example, it wouldn't necessarily reduce racial profiling in policing that fills the misdemeanor system. It wouldn't necessarily reduce the external pressure to plead created by bail, created by overcrowding and sentencing. It wouldn't necessarily reduce the collateral consequences or the embedded consequences of pleading guilty to these offenses. We need to look beyond Gideon for those kinds of improvements. And so in the piece, I just lightly touch on three central areas of possible work, many of which have been covered in other parts of the literature, but I think it's worth thinking about them as a group. So the first is to see that there have been, for decades, competing views of the potential role of public defender offices, right, to go beyond the model of the individual Clarence Darrow advocate on behalf of the individual, to understand that public defender offices could play a greater role in ensuring systemic fairness in the criminal process. And of course, Robin's work and others have highlighted the possibilities for the institution of the public defender office to play a greater role in that regard. I think that many of us would agree that we're in an era in which prosecutorial decision-making is really the center of decisional power in many ways, but particularly in the misdemeanor process. And so in the same way that Gideon has shaped our understanding of the fairness guaranteeing role of defense counsel, I think we can look increasingly to cases like Brady that highlight the fairness guaranteeing role of the prosecutor. It is a kind of, not a replacement for Gideon, but if you will, sort of a spiritual counterpart or spiritual twin to the idea that we have two players now, two institutional players, not only defense counsel, but also the prosecutor representing the government, that have some obligations to defendants individually and have some obligations to defendants as a class in order to do justice and not only to act as an adversary. And I think it makes sense that this understanding of the prosecutorial role flows naturally from our recognition that the criminal system is becoming less adversarial, right? So insofar as the system is less adversarial, then prosecutors need not be pigeonholed only as adversaries, but can fill out, I think, their institutional roles in a greater way. And then my final suggestion in the paper, the idea that we should go directly to defendants, right? That there is room for direct defendant education and empowerment. I recognize that it's problematic in a couple of ways. First, it might seem too much like giving up on the Gideon model, right? The idea that, well, we're never going to get them lawyers, so give them a pamphlet, right? And obviously I don't mean it that way. It's also problematic because direct defendant education is in tension in many ways with the traditional attorney-client relationship model, in the sense that we would be relying on information or processes outside that relationship to provide defendants with information and education. And I don't mean it, and I don't propose it as a way of supplanting or replacing that model, but more as a complement to that model. And particularly because in the arena of misdemeanors, we have in many ways, as Erica pointed out, given up on the defense model. We don't give defense counsel even to all misdemeanants who are constitutionally entitled to them. And there's very little opportunity for developing attorney-client relationships in the mass assembly line processes of the misdemeanor system. So I think here the possibilities for educating defendants directly so that they can have more meaningful conversations and relationships with their counsel when they do finally get them it probably has the most promise.
Take it away.
Thanks for the introduction, Norman, and to NACDL, and Carney, Alex, and all the students, and JD for inviting me back when? I don't remember, a while ago. It was a great chance to sort of start to think again about misdemeanors, and JD promised that we might actually get a misdemeanor panel together, so I was particularly excited about that because that's where I spend my time in the lower courts now of several different jurisdictions for most of my career as a public defender and now teaching in a clinic, first at Syracuse and then at American. So that definitely informs what I have to say here, which I guess I'll start with how I start my paper and what we've been hearing, which is, yes, there really is a crisis in the lower criminal courts. There is a misdemeanor crisis, and I hope that we don't supplant the conversation that points out that there's a mass incarceration problem in our country, but that we can sort of supplement that by recognizing that there is, and I'm sort of trying to think of what I said. I think I said a mass prosecution problem in the paper, but I just circled that, and I'm definitely going to change that. Maybe a mass criminal justice processing problem, although that sounds terrible. So give me some ideas here and think about it. But a mass misdemeanor problem to focus on today. It's important to think about Gideon in this context, and how do we give Gideon meaning in the context of the current reality of what we now have in what our criminal justice system now is. And so I want to talk about some of the underlying things that are going on there. First of all, we have legislators who can't seem to help themselves, and by that I mean they seem to be victims of the notion that creating new crimes, any new crimes, is going to help win with a tough-on-crime stance, and unable to really step back and look at the full picture of what happens when you pass all these interconnected laws that really create obstacles in daily life for people convicted of crimes. So when you step back and look at what you do to someone with a misdemeanor conviction, that it might actually be detrimental to public safety in the end. I was going to talk about how decriminalization has moved so slowly, and I think as I hit send on this paper, the news came in about Colorado, Washington, and what's the other state where it was still up in the air the other night? Isn't there one other? Anyway, that not just decriminalization, but affirmative legalization, at least in Colorado. But of course, that was the voters directly. So a little bit of movement there. And of course, there's movement based on the financial crisis going on, the fiscal crisis in states, largely focused on the prison system. Then there are the police, who also can't seem to help themselves. So we have this really entrenched zero-tolerance policing, order maintenance policing. Robin's talked about that. Really interesting stuff happening in the Bronx, so maybe some change there. But I actually went back and I was looking at Wilson and Kelling's original Broken Windows article, and what's interesting in there is when they talk about what the police were meant to do in those cases, it was the person should be sent on his way. Not sent to court, not sent through the judicial system, but sent on his way. And this is just a quote from the article. The enforcement need involve nothing more than ejecting the offender. The offense, after all, is not one with which a booking officer or a judge wishes to be bothered. So I kind of pine for that day and system. But we don't have it because people seem to not be able to help themselves or to really look at this in a rational way, which brings me to prosecutors. The sort of seeming inability to exercise discretion and screen out cases, which is not entirely true, but in a lot of jurisdictions, there's simply too much junk coming through to even be able to screen it effectively. And there is some discretion, of course, exercised in the court process. We know that a lot of misdemeanors actually don't end up in conviction, so clearly there's some discretion going on there. But the damage is already done because that person has an arrest record. And when I'm talking about criminal records in this talk, and when any of us talk about it, we have to realize the current reality that it's not a conviction record that causes problems. It is an arrest record. And those records are out there. I'll give the Maryland system, which I'm familiar with now, as an example. When you're arrested, if you're in court, the record is created. It's on Maryland Judiciary Case Search. You can Google it. You can put in a name, and you can pull anyone up, which is what employers do and landlords do. And it will show the arrest charges. If you were acquitted at a jury trial, it will say acquitted on there for your whatever the charge is. And you only get rid of that if you pay $30 and you file a petition for expungement, and only if after that acquittal you don't have a later conviction. So there's a lot of problems there. But my point being that the Robin talked about the sort of technology of judges being able to pull things up. This is part of it, but it's also the technology of anyone and everyone who interacts with you in your daily life being able to pull up a simple arrest record. And finally, defense counsel. So how can't we help ourselves, those of us who have done this or continue to do it? We can't help ourselves by just we're part of this sort of mass system and allowing it to work in a lot of jurisdictions, kind of throwing up your hands at the sheer volume of cases, and really help encourage / coerce guilty pleas in the context in which we allow our clients to take them. So I agree with Erica that the total lack of counsel in certain jurisdictions, I think it was the Alabama guy from Alabama who said, we just don't like Shelton, we don't follow it, we don't do that here. That's a huge problem, and I think it is enormously important to look at that. In Maryland, we have a statute where you implicitly waive your right to counsel if you don't get yourself to the public defender's office within a very short time period. My students, are always surprised to see people pleading guilty without a lawyer next to them and we've watched people get a year in jail with no lawyer on a misdemeanor. In Maryland, you can get up to 10 years on a misdemeanor, so it's a little bit of a strange system. So I write in the paper about the triage proposals and how in reading that literature, I was kind of disturbed by the focus of putting fewer misdemeanor resources into the lower courts, and particularly into the minor order maintenance type offenses that are in the lower courts. And I guess I was disturbed by that because I tried to put myself in the shoes of my clients and thinking, well, what happens to them in that system? I'm going to use the word collateral consequences. Sorry, everyone. It's kind of in my mind, but you know what I mean. Whatever we call it, and that name may change, and that's fine. But for now, we all know what these things are that can happen, and I won't re-describe them except to say that there are always surprises. So I was surprised to learn at one of our task force hearings, and maybe someone from California will say this isn't true, but that public urination conviction in California leads to sex offender registration. And California, this is true, only has lifelong registration. So you're on the registry for life. Now, we might think, you don't need a lawyer for a public urination case. It's true. I see a lot of nods, so I haven't put that cite in, but it was the person who testified knew what they were talking about. So there are surprises like that, and there are surprises that shouldn't surprise us, which is that these are things that employers actually go and check these records for a job anywhere, in fast food, in retail, anywhere. All right, so I guess that brings me to my proposal, which I picked a provocative title. I had disrupting before, but people didn't like that, so I just decided to poach from Michelle Alexandra and use the term crashing the misdemeanor system, and you can give me flack about that. I look forward to talking about the realistic and unrealistic parts of this approach, but it's meant to be pushing the envelope of thinking about sort of how we can get defense counsel to meet its limits. So I see it as going very hand in hand with a lot of what Sasha's talking about, which is enormously important, right? What else do you do outside of counsel? And I guess and you talked about that as a compliment to imagining what we could do, if counsel did push the limits. So I'm thinking about it as, okay, my thought experiment is let's have counsel push the limits of the misdemeanor system. And that is a role of, I guess, making the system feel what it really means to have mass misdemeanor prosecution. What are the true costs of that? We're not doing a good job at stepping back and seeing the true cost of public safety, so maybe within the criminal justice system we can force the system to feel the true costs of having more of these cases go to trial. It's well documented in the papers, and other people have talked about how few misdemeanor trials there are. That does vary from jurisdiction to jurisdiction, and so everything I say has to be taken with sort of a local calibration grain of salt. I think these things are going to be different. The solutions are going to be different in different places. There is no one size fits all. So that's a huge caveat, I guess, to all of this. The thing I hear most, and I think Sasha talked about this a little bit, is, defendants want to get out of the court system, and the way they do that is by taking a plea. And we can't stand in their way if that's what they want to do. And that's right, if that's really what they want to do, and they're informed about what's going on, and they're informed about what's going to happen to them when they walk out of court, whether they're in or out, whether it's just they want to get out of jail or they want to get out of coming back to court. And I write a little bit in the paper about the clinic experience with this, and I write about it not to say that, if you have 2 students who work with one client for half a semester and then move on to another client, that's the way we should do things. That's obviously not possible. I write about it because my experience with the students, and just like with a defense lawyer who takes the time to do this, is that the clients aren't so eager to actually plead guilty, it turns out. People may say, I don't want to come back to court a whole bunch of times, and that may be true. But if they know that coming back to court a whole bunch of times may lead to dismissal of their charge or a trial where they have a good chance at suppression or acquittal or whatever the case may be, the calculation, the cost-benefit calculation that goes on by the defendant is very different. It's very different when they're fully informed about what this really means. And I think that's sort of at the heart of what I'm proposing, that we really have to tell people what this really means in your life. And we have to tell people that, there is an option of, I wouldn't say going to trial necessarily, but turning down the quick, easy, early guilty plea. Because, of course, if you turn down the plea, we all know that doesn't always mean you go to trial. Prosecution may not have the witnesses they need. They may not want to go to trial on the case. And so to some extent, pushing back on the early plea system, I can't believe I took so long, I was going to be short. To some extent, pushing back on it can lead to many things other than a trial. I'll just quickly list a couple of other things. Not having guilty pleas at the first appearance, and I'm going to make it easy on myself and cabin off people who are incarcerated. I think bail reform has to go hand in hand with any proposal like this. So I start in the paper to sketch out ways in which we might think about crashing the system, counseling fully about collateral consequences, focusing on the sort of minor order maintenance stuff, coordinating with law clinics, coordinating with law firms. I can talk about any of these things more in Q&A. Creating practice groups so that there's expertise about particular types of misdemeanors. The point being that we need to be deliberate and coordinated in the approach to misdemeanor defense lawyering. And I guess I'll end with going back to the really important point I think Sasha makes throughout the paper, and that that we're all sort of talking about to some extent accuracy and the importance of accuracy and how the conversation is all about accuracy to some extent. It is important, but that's not what I'm looking for in the misdemeanor world. I'm looking for forcing institutional change. Accuracy is great. I have nothing against it, but I think that there's a role for defense counsel to play in saying we want to put pressure on the police to not put these things through the system. We want to put pressure on the prosecutors to change the way they screen cases, as Ron's written about. We want to put real pressure on legislators to see the true cost of a mass misdemeanor system. Thank you.
Thank you, panelists, for a great presentation. And I would like to get a very robust discussion going. Do we have till 11? Is that right? 10:45. Okay. Stefanos.
Great panel. 2 questions. The first one specifically for Erica. As I mentioned to you last night, the past work is skeptical of why the right to counsel has been expanded so far. And wouldn't a fair conservative response be that we should be taking the evidence that South Carolina and other jurisdictions can't or aren't complying, and it's not just ones that are thumbing their noses, but ones that, Pennsylvania, New Jersey, other places that they just can't get it together as evidence that maybe we need to pull back from Shelton and Ferguson. So that's question 1. And then question 2 for the whole panel. I've not heard anybody making a dynamic analysis of the system. We tend to view the right to counsel in one direction. severity of case leads to lawyer. But can't you tell a different story, which is if there's this requirement of providing a lawyer in certain cases, there was some suggestion that this might lead to, Erica touched on, might lead counties to take away criminal seeking imprisonment, for example. Well, why should that lead us to say, well, maybe instead of expanding the right to counsel to everybody, we ought to calibrate it such that, if a charge has no imprisonment, it has no serious collateral consequences, maybe no right to counsel, and that would lead prosecutors to seek the more serious sanctions less often. Because when everyone talks about decriminalization, I tend to think that outside of the marijuana context, you're not going to get huge swaths of these things taken off the books, but what you will get is prosecutors to seek the more severe sanctions less often if there's a carrot, and the carrot I envision is you have adversarial proceedings and protracted working with defense counsel less often, so maybe this is a backdoor way towards decriminalization if the prosecutors don't want to deal with the defense counsel.
Sasha, you're up first, right?
Well, I think Erica.
We're kind of interchangeable. So I completely agree with you, Stephanos, and this is kind of where I am moving. But the key thing, so I have come to believe that Alabama versus Shelton was rightly decided. But what I think we need to do that we have not been doing, and when I say we, I kind of mean society generally and everybody, is that we have to force states and counties and jurisdictions to internalize that there is a right to counsel in these cases. And then once we do that, that leads to your second point, which is that then they can't have these consequences in these cases. Instead, they've got to reformulate what the available penalties are for these offenses, and that's the easiest way or that should be the easiest way for them to get around the right to counsel to the extent that they don't have the money. And it's the South Carolina Supreme Court, the Chief Justice of the South Carolina Supreme Court, who said, we just can't comply with Alabama versus Shelton, so we're not going to. She said that, and nothing has happened. And that's what's so frustrating to me. So I don't think the answer is to say Alabama versus Shelton should be overturned. Instead, I think the answer is pressure on the states that are not complying with Shelton to make them internalize that cost. And if you say you can't comply with Alabama versus Shelton, that's not our problem. That's your problem, state. And what that means is you've got to change your penalty structure. Get rid of all of these stupid penalties that are giving, get rid of the penalties that are giving rise to the right to counsel. And I recognize all of the arguments that by saying that I am ignoring the other consequences separate from probation that stem from misdemeanor convictions. But I think it's at least a step to making the state internalize the cost of what they are trying to do to somebody. So if you want to have this penalty, fine, go for it. But you got to provide counsel. And so that, I think, is the way to get to depenalization, if not decriminalization. Because I think we're going to have much more success with depenalization than with decriminalization. And last word on this, and then I will let them respond. Bob Berukowitz has been advocating this for a long time, really, really persuasively, and he's gotten some jurisdictions to buy into it and to say, we can't afford to provide counsel. You've given us another option, and that option is actually palatable to us at this point because we can't really afford the probation sentences and the jail sentences. So longer answer than you might want it, but there you go.
The other two, you want to comment on the second question?
Well, I'm just going to follow. I think there are the seeds of a dynamic analysis out there already, and I do think that your formulation is right. To think not just about decriminalization on the books, but to understand if we understand sort of prosecutorial decision making as the real driver, right? Then how do we use that as a way of engaging in what I think sort of nicely called backdoor decriminalization? And so I take Erica's point to be that would work if we actually enforce the right to counsel. But right now we have the worst of all possible worlds, which is it doesn't matter whether the right to counsel isn't doing that work to sort of change the institutional incentives. If it did, I think you're right that we would see that. it stands to reason that those costs the charging costs and the prosecution costs would change. And I think that we need to think more about those dynamics that's what I meant by saying before. We have to understand what kind of system we have before we can understand the role of counsel in it. And I think that that's exactly right. If we understand our system, particularly in misdemeanors, is basically sort of a joint effort between police and prosecutors to figure out what happens to 10 million people a year, then we would treat that question very differently, really along those lines.
Jenny, you have a somewhat different view?
Well, I mean, I think my talk was about some back-end stuff, and certainly, you know, the hope would be legislators would change, but if not, that you make the cost felt so that prosecutors change. But I think given the arrest record electronic situation, you got to get police to change too. It's got to come down at least that far. Just two other things I would say, because I agree with everything else that's being said. So not such a different view, except to one big extent, which we've talked about before. There are no criminal convictions where there are not serious collateral consequences, and that's the world we live in. You can't take that off the table. You can't theorize a world in which you can't really talk about a world in which there isn't any. Even if there's no sort of federal, state, or local law or regulation that says you can't do this with this type of conviction, there's just the record that's out there and the employer that goes on and says, you know, okay, you gotta, you know, in Syracuse they used it, you'd go to McDonald's to apply for a job and they would hand you this yellow slip that you had to take down to the sheriff, pay $7, and they would run your arrest records, and you had to bring the arrest records back to the employer, and that was just common up there. And even though New York has a good law on sealing minor stuff, there were 12 years in which the sheriff did not seal. I think the Center for Community Alternatives has litigation over this. There were 12 years where they didn't do that, and so that stuff is just all out there. And on the decriminalization point, I mean, maybe voters have a particular place in their heart for marijuana decriminalization, but I do think, you know, that there are other possibilities. I mean, driving with a suspended license, this is Bob Baruchowicz's thing, is huge in a lot of jurisdictions. It's actually the biggest category, and that might get some resonance with voters that, you know, that should not be a criminal offense. So, you know, it's not that I want to spend all my time in lower courts, although I do like being there. I want them to be smaller. I want them to have less in them. But I do think defense counsel has a particular role to play there.
I know we've got a lot of questions, so I'm going to try to move it fairly quickly. I just want to, on this issue of the consequences, many of you may be aware of, if not, you should be aware of this ABA project to amass, if you will, all the collateral consequences. They've done 9 states so far, which are publicly available.
ABA National Inventory.
And identified over 40,000. Is there anybody here besides me who votes in D.C.? In D.C. on Tuesday, there were 2 collateral consequences on the ballot, down ballot. I have heard of at least 10 other states that had new collateral consequences coming from ballot initiatives. So they're fairly pervasive. So I'm going to go up to Abby and then come right down there. I see 3 hands in a row in that same line. So Abby.
Very quickly, a couple of comments as to sealing. I think it bears saying that any conscientious defense lawyer should advise a client that no matter what jurisdiction you practice in, there really is no such thing as expungement anymore and or sealing, because the records are out there. And that is the sort of technological reality. With regard to the right to counsel in a misdemeanor context, I think we can't talk about getting rid of penalties. I think we have to talk about getting rid of the prosecution just as a strategy going forward because of the records that exist. And I think it's an interesting strategy to take a page from what Jenny said, to focus on both arrest and prosecution, and maybe specifically much more on arrest, whether or not the legislature plays a role. Because James Q. Wilson was not really our guy. You know, he was much more their guy, and he wanted police officers to tell people to just move along. It's just sort of a useful strategy. I think we also have to tie it to police and prosecutor salaries. Too often, what happens is what happens routinely in the district, which is when we run out of money to provide counsel and investigative or expert services, the defense bar doesn't get paid. So nobody is feeling it except the defense bar. If prosecutors thought their salaries would be cut or not rise with inflation, or they wouldn't hire so many prosecutors so caseloads would rise, or if police officers felt it, maybe they wouldn't be arresting people for so many silly misdemeanors. Now I have a question. Erica talks a little bit about waiver of counsel in her paper, and Jenny sort of mentioned it a little bit too. I'm curious about what you all think should be done about that. It happens a lot in the misdemeanor context in surprising places. I mean, we're not talking deep south alone. I know you have some statistics from Florida, but it happens in Massachusetts routinely. And judges will say, you have a right to a lawyer, but you know, you don't need it. Here's what I'm going to do. You really don't need one. It happens even more so, I want to kind of throw in the juvenile context, which we haven't talked about. Of course, juveniles have a right to counsel under Gall, which took a page from Gideon. And man, oh man, is that a massive problem. So what to do about that? Because if people aren't asserting, then it's the same thing, really, as systems not providing.
Yeah, I mean, on the point of waiver of counsel, you know, there's been some good writing and advocacy around, well, maybe not advocacy so much, the responsibility of judges. And, you know, that's a huge piece of this. How do they let go on? I mean, can you imagine being is anyone here a judge? God, okay, I'm going to say it anyway. Because you wouldn't do this. Can you imagine sitting in your courtroom and watching some of this stuff happening and not doing anything? I mean, you can imagine it because we all act in sort of funny ways when cultural influences press on us, right? But it's no excuse. That one is on the judges, in my view. That should not go on. I mean, when my students are shocked at watching someone get a sentence of 1 year because they were 2 days late to the public defender's office and they need 10 days to turn around to get in there. And they were 2 days late and they send the person with a note saying, we'll come in, and the judge says no. And the person says, okay, I'll plead guilty. I don't know how to try a case, you know. And you don't get sentence bargains in this jurisdiction, and then you get a year. How can that happen? So I put that on the judges.
And I also put it on, so to the extent that you've got repeat player lawyers who are in the courtroom watching this happen, I mean, you know, my Crim Pro 2 students went out to courts across Georgia last year, and this was with the American Constitution Society and NLADA, just to look at what was going on in courts on the arraignment calendars. And they were stunned, and what they said was most disturbing to them about people just coming through and being told that they needed to waive their right to counsel, they needed to sign on this line, and then they could go. Right, and that's what they're told. You need to sign on this line so you can go. And then they, surprisingly, shockingly, they sign where they're told to sign. And what my students said was that the most depressing thing about it was to watch lawyers sitting in the courtroom, watching it happen, and not doing anything about it. And this was all before the judge took the bench. It was all the negotiation before the police. I don't think there is such a thing in a lot of these jurisdictions as a knowing involuntary waiver. I mean, the waivers are sign on the dotted line, and then you can go home. And if you say you want a lawyer, that's fine, but you're going to have to stay in jail for the next 10 days until the lawyer gets appointed, and then we will offer you the same plea. And that's what they're told.
So let me just interject about the potential role of ethical standards, both for defense counsel, for the defense bar, and really for all lawyers, including prosecutors and judges, which is, shouldn't some of this be approached from that end? I mean, Sasha, you made the point, what does the Supreme Court think lawyers are good at? And generally, the Supreme Court kind of looks to prevailing norms in the profession. They look to standards. They look to us, really, to say that. So can we approach some of this by saying, for example, it's not appropriate for a prosecutor to offer a disposition and say you have a time limit of the next 2 minutes to decide, or else that's taken away, and judges as well participating in that, and saying, well, if you're not going to take it, I'm setting bail?
Yes, I agree with that. The problem is you've got to have an enforcement mechanism, and that's the problem with the right to counsel, too. I mean, I think, and this is one of my real frustrations, is there is a constitutional right to counsel here, and people are just ignoring that, and I think it would be great to have ethical standards that say you're not allowed to, in fact, I think there are ethical standards that say that they're not permitted, prosecutors are not permitted to do some of the things that they're doing, but it's not going to change unless they get reported for it and there is a consequence to it. And so I think part of my whole argument with misdemeanors is that there are no costs to the system right now, and we need to make the players within the system internalize or feel some of these costs and effects. And I think that goes to Stephanos' point also.
Yeah.
I want to pick up on this and about feeling the cost. This is not unintentional, what you were talking about the coercion of it. At least in North Carolina, it seems to me it is quite understood to be part of what people come in, they're locked up. There is not a record at that point. There's a piece of paper. They're told something about getting a lawyer, and the way it's phrased in North Carolina has been cleared by the United States Supreme Court. You'll be required to pay it back if you come into any money. And so the two different things are happening at the time. You may make a rational decision with respect to your family. You're not going to want to spend that. You're in jail. You can plead guilty today. If you do plead guilty today or whatever, you fill out a form that's called a plea colloquy. It isn't a plea colloquy. It's you check all the boxes, and it is bulletproof at the end of that. And there is no violation of right to counsel because you waived it. And so this isn't done unintentionally, in the sense that it's a way to manage the system, and it's done in lots and lots of cases. People walk out of that court. They may walk out of that courtroom, but it is counsel will be appointed later, and you got a chance to take some action right then. And it is part of the reason that I don't think we can make states feel the consequences, of having criminalization, because there's a lot of avoidance ways, and a lot of these things will just plain happen as far as completed convictions with bulletproof waivers of counsel, and not done unintentionally at all. It's a way to manage the system.
Well, so it's one of the reasons this panel is great, right, to have a panel on misdemeanors, because the underlying problem is we need to stop treating misdemeanors like chump change. And every institution in the system treats them like chump change. Defense bar, not intentionally, but through, in many ways out of necessity, prosecutors, police, and courts. And it's not to say, right, that we've implemented Gideon the way we should in serious cases either. I don't mean to elevate that to the gold standard, but at the very least, you would not expect judges and attorneys sitting in a courtroom to just watch someone plead to burglary and everyone go, oh yeah, no problem. But we do that in millions of cases in misdemeanors, and so that's why I think. So Abby, you really asked two questions, right? To what extent are the coercive pressures and the institutional management features of the criminal system coercing or pressuring waiver? But then what about the defendants? Like, why don't they say, heck no, I'm not doing this with a lawyer? And we have taught them that it's chump change, even though it's a lie, right? And so I think that's why I like the spirit of Jenny's proposal. However we do it, there has to be a way of elevating the understanding of the importance of this class of criminal offense and criminal consequence, not just internal to the criminal system, but also in the minds of people who get arrested for loitering or trespassing, and to understand that this is actually a life moment that they need to pay attention to.
Yeah, and I think that's why the education piece, which you talk about and start to talk about, is so important in this, of telling people, getting the word out. Because it's great when a client says to the lawyer, "Hey, what about this? Why aren't you know?" On the point of the system finding avoidance techniques, it's always going to find avoidance techniques, and so. At the end of the day, I think you got to get the stuff out of the system, because the system will find avoidance techniques. To the extent that it's in the system and you want to try to fix it there, that's why no proposal standing alone is going to work. It has to be a very coordinated effort to change things in the lower courts.
I'm going to go to the second row and then up to Robin after that.
So I think this is a good place to pick up, because, why isn't the solution
even if we can't make a chump change, to make it kind of chumpish change. So I'm thinking specifically about kind of a European penal order model, where what you would do is you would have a police interaction with a citizen, and they would issue them something not unlike a ticket, which if the person simply signed off on, did whatever they had to do as was prescribed by the ticket, some monetary fine, some amount of community service, or for the indigent, civil judgment would be entered, that would be the end of it, with a conviction to a violation, not a crime, without the attendant enmeshed penalties. If they decided to challenge it, then they enter the criminal justice system, they get a lawyer, and they fight it as a misdemeanor. In that way, you can, I mean, look, I understand it's not chump change, it's kind of chumpish change, in that police are still going to be stopping and frisking these people, although they're going to be stopping and frisking them even if they can stop and frisk now without making an arrest. I think if you do it, if you design it in the right way, it wouldn't have to appear on an arrest record as an arrest. And that may be a way to empower the defendant to choose whether they want to exercise the right to counsel, which would come at a cost, whether they want to engage in process and all of the process costs attended to it, or whether they would just want to step away in a manner in which they wouldn't be saddled with these enmeshed penalties. Because I got to say, Jenny, with respect to like the sort of Steve Zeidman-esque point that we should not have pleas at arraignments. I'm sorry, but with a criminal justice system as pathological as ours is, if there's one pseudo-good thing you might be able to say about it, is that it can be quick if a person wants it to be quick. And it strikes me that when we're saying, no, you can't have it be quick even if you want it to be quick, you got to come back a couple days. We're using the defendant as a means to crash the system. We're using it as a means to crash the system because you say it yourself, the case isn't going to trial. They are ultimately going to take a plea. It's going to be rare that they ultimately go to trial. Instead, it's just going to be a burden on the prosecutor. It's going to get prosecutors to think twice in the future, which is a good incentive, but I don't love the idea of using the defendant as a means to create that.
See, I think we're using the defendant now as a means to let all this stuff go through. And so, my proposal is not to use the defendant. I think that's. I'm just saying. Look, it's hard because, and I'm certainly. No, but I think it's the most salient critique of the proposal, right? Mm-hmm. Which is you can't do this to people because your ethical duty as a lawyer is to represent individual clients, not to represent a cause or to make institutional change. People might disagree, but a lot of people agree that you represent the individual client. They're going to make the choice. If they want to plead guilty at arraignments, but again, we're not all in New York City, so it's not the same out there everywhere. And that's one thing I've learned about being in different systems is that's a very New York City focused view. And Steve Zeidman says it about New York City, but it's much easier to say it about other places. There's a lot less process cost in a lot of systems to say no at arraignments. You come back, in Maryland's a de novo system. You leave arraignment, you can't take a plea at arraignment. You leave arraignment, you come back on your trial date. And if you don't like the result in your bench trial, you get a jury trial de novo in circuit court. There are many problems with this system as well, but it does lead to more people taking trial because the process costs are lower. But if a client comes in on their first trial date and they want to plead guilty, if they know what that really means, then of course the lawyer is going to,
So I want to, before I go to Robin for her question, I want to take that point and I want to quote something, and recognizing this is a draft, Erica, but I want to read this quote and then ask you to respond to it. You say that it's possible misdemeanor defendants are not insisting on the appointment of counsel because they actually do not want counsel, or at the least it is not sufficiently important to them. And to the question that was just asked, so in the light of that, I ask this question. Is it possible that one of the reasons that it's not sufficiently important to them because they haven't had someone explain to them what the ultimate consequences may be down the road.
Yes, absolutely. And I think, this goes to the waiver point as well. We don't know why, to the extent that people are not represented, why they're not. We don't know why defendants aren't squawking about it more. I do think that there is a lot of pressure from the system for people to waive counsel, and I agree, it's very intentional. And I think that has a big part to do with it. But there may be some people who say, I don't want counsel, and I think that's fine if that's what they say and that's what they want.
I just want to respond to Josh's earlier point. So it seems to me you're asking sort of the multi-million-dollar question, which is decriminalization possible, right? And we can think of ways of describing it, but I think it goes to something that I've written about elsewhere and I'm still thinking about, which is, so in many ways we run the misdemeanor system in ways that are not like the criminal system at all, right? It has nothing to do with culpability. We don't really require evidence, and there's no due process. So we're like, in what sense is this a criminal system? The thing that's criminal about it is the consequence, right? The punishment, the embedded consequences. So people come out of it labeled criminal, but we don't behave in the sort of classic criminal procedural way all the way up until that moment. And so your question, can we decouple sort of the normative significance of what sort of broken windows, this is chump change, like let's treat it as chump change, from the habit that we've gotten into calling the process criminal and then treating the outcome as criminal. It goes to Norman's point before. Are we a country of criminals? I mean, the 10 million misdemeanor cases a year, really, that's a lot of criminal Americans. We probably don't think that that's actually what they are. And so it seems to me that question of, can we treat it as a ticket? Or can we train police to handle it differently? Or maybe more saliently, can we have prosecutors treat it differently? It goes to really a deep cultural question of how tied are we to the criminal label for these things? And can we decouple what we've come to see as a criminal process from sort of the underlying work that it's really doing? So I think that's really the question.
Okay, well, I'm going to close it out now by making this, reading this statement to you. Serious consequences also may result from convictions not punishable by imprisonment. Stigma may attach to a drunken driving conviction or a hit-and-run escapade. Losing one's driver's license is more serious for some individuals than a brief stay in jail. When the deprivation of property rights and interests is of sufficient consequence, denying the assistance of counsel to indigents who are incapable of defending themselves is a denial of due process. That is from Justice Powell's concurrence in Argersinger 40 years ago, long before we invented this massive concept of all of these consequences. And to me, that just resonates, and all of the ideas, I mean, everybody, I think, there seems to be one consensus, which is we've got to shrink the system. We've got to find whether it's this alternative model where somehow the cases can be resolved before they're even written up, before there's even the possibility of a record that can be technologically disseminated to the world. That's really the challenge. How do we come to grips with it? And the three of you have really, I think, tremendously helped advance this conversation. And I know I look forward to the publication of the final papers. And I want to ask all of you to join me in thanking them for a wonderful presentation.